most of them, three of the others, had said that when the purpose of government is perverted and all other means of redress are ineffectual, the people may reform or replace that government. Only two go farther, Maryland and New Hampshire, which say the people may and of a right ought to reform or replace that government, which makes it the moral imperative. And then the last sentence, well, in Maryland it's a clause, in New Hampshire it's a sentence. The doctrine of non-resistance against arbitrary power and oppression, the long way of saying tyranny, is absurd, slavish, and destructive of the good and happiness of mankind. Now, if New Hampshire were a knockoff of Massachusetts, it wouldn't say that, because that was taken from the Maryland Constitution. All the other states prescribed an absolute separation of powers between the powers of government, legislative, executive, and judicial. Only New Hampshire said they ought to be as separate and independent as the nature of free government will admit. Now, all the other states did have checks and balances, but only New Hampshire, in the wording of their Article 37, articulated the need for checks and balances. The recognition that there must be checks and balances. This is important, and in fact, Madison in Federalist Paper 47 makes special mention of New Hampshire because we got it right. And then he recognizes the fact at that point in history we had a parliamentary form of government, as did 6 of the other states. So New Hampshire is not a knockoff. It is, in my opinion, the best summation of American liberty, because it looks back retrospectively over all of the other state constitutions and takes what every other state did right and rejects what they did wrong. It is the summation of American liberty. The next state constitution after that, Vermont, is a degradation. They, for instance, they no longer say ought to reform or replace that government. That's a very important distinction. That is one of the key issues in New Hampshire, is that you have the best written Bill of Rights. Not only that, you have the least altered Bill of Rights. Article 32 recognizes our right to petition for redress of grievances before the legislature. Several of the other states had that same recognition, but Massachusetts traded it for a right of petition, which is regularly ignored by their legislature. And that right of petition has very strong prescriptions against doing anything against the judiciary. You cannot, for instance, you cannot impeach a judge by petition. You cannot remove a judge by bill of address by petition. You cannot alter the rules of the court by petition. So they lost. All of the other states that had a right of petition to redress before the legislature have altered it so that it is no longer a right of redress before the legislature, but a right of redress before government or those in government, which admits other bodies such as the executive, which is more remote from the people, or the judiciary, which is entirely insulated from the people, to be the point at which you complain against government. Only New Hampshire still has the exclusive right of redress before the legislature that you can demand. And this seems like a great diversion from the idea of states' rights, but it's not. The reason is you have to understand where these rights came from. If you go through the New Hampshire Bill of Rights, you'll find that most of the rights that these people knew were their rights as Englishmen. They knew that they were their God-given rights. These rights didn't spring up. They weren't invented in 1776. This was part of their cultural history. Most of the articles of the New Hampshire State Constitution originate in the Magna Carta, which was written after the Baronical Rebellion of 1215. Most of the rest of them come from the English Bill of Rights, written in 1689. Happens to be the year that New Hampshire was formed, but the English Bill of Rights was what King William and Mary agreed to in return for their being put on the throne. This brings a very important philosophy of liberty. No government has ever willingly recognized the liberty of its citizens or its subjects. Every advance in liberty, whether it's the Magna Carta, or the English Bill of Rights, or all of the state constitutions that came out of the War for Independence here, were obtained by the force of arms or the threat thereof. That's why we have a Second Amendment, and why many of the states have a Second Amendment, is because they recognize that only if you have the ability to push back the government can you defend your rights. So if most of the rights came from the Magna Carta and then the English Bill of Rights, what about the others? There's 11 other articles that have no tie to previous documents. There are Articles 1 through 10, and then Article 38, which was originally the last article in the state constitution until the 1960s. I mean, in the Bill of Rights. Articles 1 through 10 and Article 38 are what our founders of New Hampshire referred to as evangelical principles. It was stated that way in the original wording of Article 6. Article 1 is that all men are born equally free. Now this is important. No word in that Constitution is wasted. All men are born equally free and independent. It didn't say they were equal. They were equally free and independent. Therefore, now this is another important distinction. All of these evangelical principles, these rights, come across as principle, therefore. Okay. All men are born equally free and independent. Therefore, all government of right is founded in consent, instituted for the common benefit, and I can't remember the third one. Let's see. Originates in the people, is founded in consent, and is instituted for the general good. And remember, this is important. General good means that whatever the government does, it does equally for everybody at the time it does it. So that it doesn't admit paying into a Social Security system now, while everybody else takes out of it, and maybe you'll get some in the future. Okay? Everything the government does, it has to do equally, it has to affect everybody equally when it does it. All men have certain natural, essential, and inherent rights, among which are enjoying and defending, that's a new concept associated with evangelical principles, life and liberty, acquiring, possessing, and protecting property, and in a word of seeking and obtaining happiness. There was more added in 74, but I don't, it's really superfluous. Equality of rights under the law shall not be denied or abridged by this date on account of race, creed, color, sex, or national origin. Well, if all men are created equally free and independent, that's a given. Article 3. When men enter into a state of society, they surrender up some of their natural rights to that society in order to ensure the protection of others, and without such equivalent, the surrender is void. So, if you've surrendered certain of your natural rights, like, for instance, when you enter into a state of society, you surrender up absolute right to your property in the form of taxation, so that the protection of your rights can be paid for. But if that protection isn't provided, then the surrender is void.